This case starts like a routine probation hearing, but within minutes, it turns into a courtroom reality check. A young defendant facing drug use and resisting charges, a defense attorney challenging police testimony, and a judge who refuses to let facts get twisted. When video evidence enters the room, everything changes. Was an officer actually punched, or is memory colliding with camera footage? Stay locked in, because this hearing becomes a masterclass in accountability, credibility, and how fast a courtroom can shift when the truth is put on screen.
Rodney Sean Tuttle, 25B701845. Again, counsel, I can't apologize enough.
Right here, the stakes are quietly set, and they are serious. The judge makes it crystal clear she does not tolerate violence against law enforcement. That matters legally, because an assault on an officer can instantly escalate consequences. Meanwhile, defense counsel tries to soften the picture, employment, context, explanations, but notice the imbalance already forming. The judge is focused on actions, not excuses. This is the first warning shot. If the facts support an officer being struck, leniency is off the table. Do you think the attorney is laying groundwork or already on shaky footing?
I'm sorry.
Quite all right. I was running late myself.
Okay. Well, I wasn't running late, but things are always happening around here. Your name?
John Freeman, I'm Mr. Tuttle.
Mr. Tuttle, your name?
Sean Tuttle.
Your client pled to attempt R&O, and use of meth. So we've got 3 counts. Have you had a chance to review the report with him? And are there any material additions, corrections, or deletions?
Your Honor, I should note that he is currently employed with his father in the state of Kentucky doing construction. It is an under-the-table kind of job, but he is working. I can appreciate that the court might want some verification of that moving forward, and I've explained that to him. There is, it says here that he's not employed, but he is in fact working.
All right. Okay, I'll modify the report in that aspect.
Your Honor, other than that, there are no additions, corrections, or considerations.
All right. Anything you'd like to say? And I'm going to just tell you, I don't go for this guy hitting people and hitting police officers. So he might not be walking out the back exit way today. Okay.
Well, Your Honor, I'd ask that you reconsider that. I've watched.
This is the turning point. The defense directly challenges the officer's written report, specifically the claim that the defendant punched him in the forehead. That's a bold move, because once you dispute sworn testimony, you invite verification. And that's exactly what happens. The judge doesn't argue, doesn't speculate, she does something far more dangerous for a weak claim. She calls the officer in, live, and asks to see the video. In court, credibility isn't about confidence, it's about evidence. Would you have pushed this argument if you were defense counsel?
The video in this matter. He was given a lawful order by the police. He did run from the police. The police did have to tackle him to the ground.
The officer says here, as I reached out to grab Tuttle's wrist, he pulled away from me. I reached again for his arm. Tuttle punched me on the right side of my forehead. I lost my balance and fell down to the ground, and Tuttle took off running northbound on Kirby. Are you saying that the video doesn't show that he got punched in the forehead?
I did not see that in the video. I saw.
Where's your office at?
In Bluefield Hills. My view.
Watch how carefully this unfolds. The officer doesn't exaggerate. He doesn't double down aggressively. He acknowledges memory, admits uncertainty if the video differs, and even expresses concern about accuracy. That restraint matters. Judges evaluate not just what is said, but how. This is credibility in real time. The defense hoped the video would clearly contradict the report, but instead, ambiguity enters the record. And in court, ambiguity rarely favors the person resisting arrest. Who do you think is coming across as more credible at this point?
The video is that it was basically a struggle while my client was on the ground refusing to be handcuffed. And I know that Mr. Muhammad had direct communication with the officers involved in the case before.
Hang on 1 second.
Yes.
Hey, this is Judge McNally at 33rd. Can you, I need to know if Officer McParland from Brownstown is on duty today. Perfect. I'd like him to appear on Zoom for me right now, okay? I'd like him to, I've got this Rodney Tuttle case and I'd like him to zoom in. Okay? Thank you very much. Why don't you have a seat 1 second? As soon as he zooms in, I'll recall it, okay?
Your Honor, I do have the video on my laptop. Wants to watch it.
Okay, I might take you up on that. Okay, thank you. If he tells me what's in the report is accurate and you think it's not, I'll be glad to look at that video. But you don't punch police officers in the forehead or in the face or anywhere else. So, all right, well, we'll find out. Timothy Allen Gallagher, 25. Rodney Sean Tuttle. And I want Officer McParlin here, 25B71485. Good morning, officer. I'm going to ask you to take your hat off. Tell me your name, please.
Yes, Your Honor. Excuse my error. I'm Officer Gage McParlin with the Brownstown Township Police Department.
Names again over here.
John Freeman on behalf of Mr. Tuttle.
Name.
Ron Sean Tuttle.
All right. So one of the things I pointed out, he pled to attempt, resist, and obstruct. 2 counts, a 1 year. And then he pled also to use of methamphetamines, which is a 1 year. And I pointed out, I read in the report where you said he punched you in the forehead. And his lawyer's saying it's on video and he's inviting me to see the video and I'll be happy to look at the video. But he's seemingly disputing that. He's saying that you tackled him, right, Mr. Friedman? I don't want to put words in your mouth.
So, Your Honor, I just rewatched the video. So my client is given a lawful command to stop. The officers wanted to speak to him. He refused to do that, and he started to move away from the officers. So I believe it was this officer that's currently on the video, attempts to tackle my client. He is the person that initiates the physical contact. My client begins to run. And during the course of trying to run away, this officer loses his footing and falls to the ground. There's a second officer who is involved in the pursuit. This is all visible to me, at least, on the body worn camera footage of the second officer who's a little bit farther behind. I do not see anything on this video of my client attempting to strike.
He didn't say attempting. His report says he struck him in the forehead. That's what it says.
And
He said, as I reached out to grab Tuttle's wrist, he pulled away from me. I reached again for his arm. Tuttle punched me on the right side of my forehead. I lost my balance and fell down to the ground, and Tuttle took off running northbound on Kirby. And then he talks about how he and Officer Grimm tackled Tuttle to the ground on the cement driveway. While Tuttle was on the ground, he continued to fight with me, resisting arrest. Grimm and Novak, fighting with me, Grimm and Novak. I personally had to knee Tuttle in the ribs to get him to surrender his hands. I also attempted to strike Tuttle on the shoulder, but he moved and I struck his face. After 2 minutes of fighting / resisting, we were able to handcuff him and place him in an upright position so he could breathe. So I'm just asking you, because I'm going to look at this video.
Yeah.
Did he in fact punch you in the forehead?
Your Honor, I remember being struck as I went to grab Mr. Tuttle, and at that point I fell. That's what I remember. If the video shows anything different, that is just, I would like to see it as well, but that's exactly what I remember. And my video camera fell off. But that is exactly what I remember.
Can I see the video?
of course,
All right. You want to pull it up here?
give it up.
He's got it on his podium here.
Watch how carefully this unfolds. The officer doesn't exaggerate. He doesn't double down aggressively. He acknowledges memory, admits uncertainty if the video differs, and even expresses concern about accuracy. That restraint matters. Judges evaluate not just what is said, but how. This is credibility in real time. The defense hoped the video would clearly contradict the report, but instead, ambiguity enters the record. And in court, ambiguity rarely favors the person resisting arrest. Who do you think is coming across as more credible at this point?
At the podium, Lisa, can we, tech savvy, I'm not. Can I get it up on the screen there, or?
I'd also be happy to step up and try to facilitate the court watching it on my laptop. There is some audio to it.
Yeah.
If he wants to join the Zoom, he can do a share screen, or he can send it to me and I'll share screen.
Friends joining the Zoom.
Okay. let's have you do that. I'm sorry to call you on such short notice, officer, so just bear with us if you will, please.
Not a problem, Your Honor. I don't want to be wrong in this case, so please, yes, pull it up, and thank you for calling me.
No problem. I hate to do this, but while you're doing that, I'm going to go on to another case here, okay? Mark Charles Matthews. Okay. Now we're going back. Give me 1 second. Now we're going back on Tuttle. All right, recalling Rodney Sean Tuttle, 25E71485. You and your client can sit right there, counsel. Okay. You don't have to stand at the podium. Come on over and sit next to your lawyer here, Mr. Tuttle. And Officer McParland, I just want to make sure you can see this as well. You can see this?
Thank you, Your Honor. Yes, I can see it.
Okay, you can go ahead and start the video.
So, Your Honor, I'm not sure about the audio part because there was some feedback. So I don't know if the courtroom has to be muted. I assume the court wants to hear the audio.
Yeah, let me see that. Let's, if we have a problem, I'll tell you to stop it, okay?
So, Your Honor, I can hear it here, but I can't. I don't know.
I'm here. I'm able to hear it a little bit. Yeah. All right. You can approach the podium and let's finish the sentence. Officer McParland, you are the victim on this. You are welcome to tell me whatever you'd like to say.
Just one thing for clarification, Your Honor. Again, the video I can't really see very well, but I don't want to put or make any statement if I made it wrong or whatever. Did you see him strike me? I cannot see the video.
Looked to me like he did at one point when you went toward him. It looked like in the process of him trying to get away that he did take a swing, but I'm not positive about that.
All right, just because I don't want to be an officer known for any kind of like someone think I just falsified anything here because if I'd set the record straight. But continue, Your Honor.
Nobody thinks that. Okay.
All right. Yes, Your Honor. I appreciate that.
Do you want to say anything else?
After the video plays, the tone shifts noticeably. The judge isn't declaring a dramatic gotcha moment, but she's no longer entertaining doubt. Even the officer acknowledges uncertainty, yet the broader narrative remains intact: resistance, struggle, escalation. This is where defense momentum stalls. The courtroom isn't about winning arguments, it's about whether the judge feels confident in the facts. And here, that confidence is settling in. Did the video help the defense, or quietly seal the outcome?
Mr. Tuttle, if I could speak directly to him, if at all possible, Your Honor.
Sure.
Or the court. Mr. Tuttle, despite what happens, sir, I really hope you get the help you need wherever you're going in life. All right, buddy? I know I know you were on Allen Park. You had an incident there. I wish the best for you and your family, okay?
Appreciate it.
Not a problem, man. Good luck, brother.
Can I have 3 probation? Counsel, what else would you like to? You're free to sit there if you want still. I don't have any problem with that.
It feels awkward, Your Honor, for all of your side.
I get it. I'm sorry. I didn't mean it was in that, the probation orders. I'm sorry.
Oh.
I'm not probation. Yeah. Orders of probation.
So, Your Honor, since I first started interacting with my client back months ago when I was hired on this order, my sense is that he's been doing everything right. He was living in Florida for this event, and he went through a rehab program there. He was working gainfully employed with Amazon, and he just seems to be on the right track. And I'm really concerned that ultimately, if he has to do the incarceration, that it's going to derail the progress that he's made. So I'm going to ask the court to follow the recommendation. My client has relocated to the state of Kentucky where he's got stability and living matters.
So he's actually living in Kentucky now.
Yes, sir. He started out in Florida. He came back here. You may recall there was an issue about him needing to have his fingerprints taken.
Yes.
I did all of that. He's been here for the 2 in-person court appearances. So now he's residing in Kentucky with his dad, where he's working. We have no objection to the recommendation. I think it's very fair. I think that addressing what's going on underlying with Mr. Tuttle's behavior is going to be the key to success. And hopefully he never has to appear before a judge like this again. He recognizes that he's got to do a lot of work in order to make sure that that happens. And I would just ask the court to follow the recommendation, give him the opportunity. Your Honor, the court also, the last time we were here, directed him to appear or to attend AA meetings.
Yeah, because he wasn't doing it, right?
That's correct. And I do have, he's got a sheet here that's been signed that shows consistent meeting attendance between November 15th and December 7th. So I can provide that to the court.
No, I trust you, counsel. I believe you.
Your Honor, I think the video speaks for itself. I think the court has a clear grasp as to the facts of the case. And I'd ask that you show some mercy to my client.
All right, 18 months probation. You cannot leave the state without the consent.
This is a key legal lesson. Instead of jail, the judge imposes structured probation, strict, detailed, and demanding. Drug testing schedules, travel restrictions, AA attendance, intensive outpatient treatment, and financial penalties are all spelled out clearly. This isn't leniency, it's conditional mercy. The court is saying, you get freedom, but only if you follow every rule. One misstep, and incarceration is back on the table. Do you think this balance between punishment and rehabilitation is fair?
The court or violate a law. You change your address, place of employment, or home telephone number, you must notify probation. You have to report as direct. No alcohol, no drugs. Stay away from that, nothing. No alcohol, no drugs of any kind, not marijuana, anything. No alcohol, no illegal controlled substances, no marijuana. You can leave the state to go to Kentucky. You're not to purchase, possess, or consume alcohol or drugs. You're submit to chemical testing, PBTs and ETGs as follows. I'm going to make it weekly for 2 months. If you're clean, I'll make it bi-weekly for 2 months. If you're clean, I'll then revert it to monthly. Okay? Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. Again, you're to attend AA, NA 3 times a week until I think he needs intensive outpatient treatment counsel. I really do. He's got too much of a history here. So 3 times a week until an IOP. Once you get into intensive outpatient treatment, you no longer have to attend AA or NA. Okay? Do you understand all of this so far?
I really don't understand what intensive outpatient is.
All right. Well, it's more than once a week. They're going to be having you go 3-4 times a week. Okay? And probation will explain that, and your lawyer will explain that. I think he has 1 day credit coming from the arrest. Is that true, or does he have more than that?
I think it's just one.
Okay. All right. I would make him do the court work program, but I'm not going to since he lives in Kentucky. 10 days jail, credit 1, serve 9. I'll let you serve 9 days of community service. That has to be completed by February the 20th of 26. In terms of fines and costs, and on count 1, I'm going to attribute everything. $100. What happened? $100 fines, 75 costs, $60 screening fee. That is $235. Probation fees are $360. That's $595. And then you have 75 and 50 for 75 victims' rights fee, $50 justice assessment. So that's another $125 on top of the $595 for a total of $720. I believe on the other 2 counts, I'm just assessing 50 and just the justice assessment fee. So $100 fines, 75 costs, $50 justice assessment, 2.25 on both of those other files. Okay, so 100 fines, 75 costs, and $50 justice assessment. So that's 2.25 on those. I'm not going to charge you again, or 365 days. All of these terms and conditions are running concurrent. Do you understand that, Mr. Tuttle? All right. All right, so counsel, he owes 720 plus 450 or 1170. Can he pay all that today?
Your Honor, would the court consider a 2-month payment plan?
I don't have a problem with that. Okay, so let's just do this. Just give me 1 second. There's a lot of paperwork here. All right, so how do you want him to be able to pay this, counsel? In other words, why don't we set up a payment plan and
Would it be easier if the court just set a due date for?
yeah, I'd rather have them do that. I'd rather set up a weekly or bi-weekly or monthly or what have you. So how much can you pay weekly, sir, or bi-weekly? Can you pay $100 bi-weekly?
Yeah.
Well, let's just do that. $100 bi-weekly beginning December 23rd. And then you just pay every other week. If you don't have the money, call the court. We'll go on Zoom. I'll give you an extension. We're not going to have a problem. Just don't ignore me, okay? You'll meet with probation before you leave. Any questions?
Probation paying, just out of curiosity on how the.
You're going to talk to probation. They're going to have you test in Kentucky. You don't have to drive back to Michigan. And yeah, they'll answer all your questions. And if they don't, you can come back in here and ask me, okay? Anything else?
No, thank you.
Have a nice day. Take
Thanks.
care. Enjoy your Christmas and everything. Thank you. I know I've got people waiting here.
In the end, this case shows how quickly courtroom narratives
mercy
can
to my
collapse
client.
under scrutiny. A
All
disputed
right,
punch,
18
a
months
challenge
probation.
report,
You
a
cannot leave
video
the state
review,
without the
and a
consent of the
judge
court
who
or violate
refuses
a
to
law.
rule on emotion
You
alone.
change your address, you place your
The
employment, home
defendant walks
telephone
out
number,
with
you must
probation
notify
instead of
probation. You
jail,
have to
but under
report as
intense
direct.
supervision that leaves
No
zero
alcohol,
room for error.
no drugs.
This
Stay
wasn't
with
about
them,
winning,
huh?
it was about accountability.
No alcohol, no drugs.
White right pointing backhand index if you found
of
this
any
case as
kind,
shocking
not
as we
marijuana,
did. Make
anything.
sure to hit
No
that like
alcohol,
button,
no
share your
illegal
thoughts in the
controlled
comments,
substances,
and
no
don't forget to subscribe for more
marijuana.
jaw-dropping
You can leave the
courtroom
state to go to
breakdowns.
Kentucky. You're not to
Scales hash
purchase,
fire.
possess